I have been working on a paper on the disruptive role of AI for the banking and finance industry. This is an abstract on a working draft, so I will be sharing with you my brief thesis, the methodology I'll be following, and the basic ideas that I'm trying to spin into why the disruptive wave of technology in terms of why there are certain industries today that have become relevant, why there are certain demands that have been tapped into and why there are certain industries that which used to be relevant have become redundant in the sense that they really don't have the kind of demand that used to exist before. So the kind of inquiry that this paper really undertakes is the fact that every historical epoch is characterized by a change that causes us to think the impact that it will have on us. So we always want to believe, the optimists want to believe about the essential positives of the changes that might come to us. So when the internet age came into being, everybody was very excited because there were new possibilities, for business, new possibilities for medicine and pharma and for general connectivity. But also there are other, I would say, reservationists who believe that the internet has led to some sort of societal downfall and a collapse in societal values. So the primary idea that I'm trying to portray here is the fact that the way we harness and the way we respond to changes that occur in our society essentially lay the foundation for how the future would pan out for us. Now, when we talk about the Industrial Revolution in the 1800s, the essential change that came about was the fact that all of the assembly line workers, all of the factories were characterized by automation. So automation essentially was the fact that the primary objective was profit maximization and everybody wanted a greater deal of efficiency. So humans were sort of relegated to more service-based industries and technology overtook the factories. Now, the internet age has been born and has sort of collapsed, and I wouldn't say collapsed, I would say has been assimilated into the information age where data is power. So if you look at e-commerce companies and if you look at other companies, what they're really doing right now is developing the technologies to tap into data effectively. So a lot of policy considerations come into play here because competition law would say that e-commerce businesses who have the ability to tap into consumer behavior and consumer interests and desires are at a much more competitive edge than companies who cannot. For example, Google has devised an app called AdWords that essentially, it essentially feeds into your data and all of the searches that you undertake on their website, and it, conducts algorithmic studies on what consumers really want, and then you get those tailored prompts about what you want to buy. So sometimes we feel like the government is spying on us, but it's really just, a very sophisticated handling of information. So that's essentially what I'm trying to talk about here, which is the ability to harness data effectively and the ability to create data mechanisms that help us advance our industries and the services that we ultimately as consumers utilize is the primary objective of the information age. So why is this inquiry relevant from a scholastic point of view? The primary reason is that the rise of the information age is inevitable and we really can't exist without understanding how to tap into this information carefully and in manners that are efficient. So it lays the foundation for the future and the fact that this is something that we really can't escape. And moreover, developing technologies at the present would determine whether or not we would be able to capitalize most efficiently on it. So I don't have a thesis to begin with as of now, but I am accumulating information descriptive sources from elsewhere to really understand the effect that tech disruption is having on the banking and finance industry. So it's mostly an observational point of view at this particular point, and I would be collecting more information as I go along. So the paper that I'm working on would be divided into 3 parts. Now the first part would essentially deal with the traditional banking system and the legacy systems of banking that have been into place since the past, the way that we would generally go to a bank, deposit our money, engage a personal banker, engage in the documentation and the drudgery and all of the work that comes along with it, and how the financial crisis has laid down the foundations for the challenges that we face today. there's a very high sense of distrust that individuals and mostly mid and small level borrowers have in the finance industry. We feel that our money isn't being handled carefully. We feel that the financial assets that are being provided to us and the services that we're using aren't personalized and customized as opposed to, say, our Amazon purchases or our Flipkart purchases, right? So that's what the first part deals with. The second part engages with how AI and particularly big data, which essentially connotes data on a very large scale and a very sophisticated analysis of that data in real time to understand how we consume and produce information. So how that is impacting the banking and finance industry. Now the third part is a discussion of the pros and cons. So with every technological wave, there comes a point where you need to stop and ask, wait, is this really as good for us as we deem it to be? So these are some of the challenges that AI, I believe, will help tackle, but there are obviously some cons that pose a threat to the human workforce and whether we will be able to keep up with the pace of advancement in technology. Now, the global financial crisis arose out of a subprime mortgage lending process that the US banks and consortium of banks were undertaking. And this essentially meant lending to people who did not fit the correct credit rating or did not have the credentials to be eligible for the loans to engage and to buy housing and to essentially have access to the services that people in the higher income strata had. But the problems that this crisis led to were massive. The problems that it led to essentially entailed a recession that was worldwide and that some countries, especially developing countries, are still trying to climb out of and rebuild themselves from. So it essentially broadened the pool of potential lenders who may not have been otherwise qualified, but it also created a lot of macro level risks that sustain themselves into the next decade. So a Deutsche Bank study that had been conducted the past 2 years ago essentially talked about new global developments like the Brexit and the uncertainty surrounding how the Brexit is formally going to go through. It talked about a slowdown between Chinese and American trade relations and the domestic slowdown of Chinese growth. So all of these macro risks still regulate how the finance industry governs today. So if you take a shift from these macro risks to the potential micro risks that tech, AI and big data would bring into the finance industry, we would not essentially be changing or eliminating risk entirely, but modifying the kind of risk we choose to run. So that is a big determinant on how we finally outlay the future for finance and banking, because banking, the basic premise of banking is undertaking a certain degree of risk that would yield a certain degree of return. So it's not elimination, but a modification of the kind of challenges we want to tackle. Now, the collapse of the Lehman Brothers at the end of the 2008 financial crisis, and probably one of the main events of the 2008 financial crisis, caused widespread distrust in the financial system, as I already mentioned before. Now, although they had surgically targeted and created a lot of domestic solutions to these problems, what essentially happened was that this distrust sustained itself into the next decade and it really didn't dissipate. So although technological advancements have occurred in terms of how we consume products, in terms of how we connect to others, the general technological environment has really advanced, but the way we undertake banking has more or less remained the same. So legacy systems of payment remain the same. You still have to go to a bank, engage a personal banker. Settlement costs are very high with banking. If you want to wire certain transactions, that's a very big problem for people who work in developing countries and have to wire money back home. So they spend a large amount of their actual earnings on sending that money back. So the challenges that the banking system faces today have not dissipated due to the rise of technology, but have in fact been, I would say, have been aggravated because there's a certain monopoly on the kind of information that exists within banking, right? So that is something that has been exclusively been kept out of the reach of the consumers to create some sort of intimidation and a sense of dauntingness that scares them and intimidates them to accepting whatever terms the banks place before them. Now, essentially, the finance system and the banking system and the global lending system is very skewed in the hands of the people who hold this power. The big banks, the consortiums that dictate the terms of the loans that you would be ultimately taking, and placing very, very high margins on basic consumer services like wiring money, or engaging a banker to tell you what's best for your portfolio and all of that. But the challenges it faces today are very specific. For example, there are very high settlement costs. If I were to wire my friend some amount of money, the amount of time, money, and resources it would take to ultimately clear that transaction would be very high. So this creates a lot of back office expenses for the banks, which they ultimately place on the consumer's burden. The second problem that it faces is the clearance of transactions. Again, with the wiring of money, institutions like the Western Union place a lot of burden on the consumer's resources and pockets to ultimately clear the transaction. The third problem is the high risk of financial fraud, and I believe this also stems greatly from the corporate governance standards in banks. For example, some of you may have read about the rising NPA crisis in India, wherein the Vijay Mallya, the Kingfisher crisis, and the recent Chanda Kochar corporate governance fraud. So the fact that the internal mechanisms of banks and how these people at the highest helms of power have this unabated and unregulated access to credit, as opposed to people and consumers who don't have that kind of access just because of the strata of society they come from. This, I believe, is a discrepancy that data can help bridge. So one of the applications of AI and big data is blockchain, which is essentially a distributed ledger system, and it leads to the instantaneous clearance of transactions. Now, the most dominant use of the underlying technology of blockchain is Bitcoin, which is essentially a form of digital currency, which the idea for which was given by a pen name, Mr. Satoshi Nakamoto, who later on went off the grid. However, the underlying technology for blockchain has been widely embraced by governments, and they're very open to adapting it within their banking systems. For example, in 2018, August last year, the RBI established a specific unit for research and development in cryptocurrency and blockchain. So governments are slowly opening up to the idea that they cannot entirely avoid data, and they can't entirely avoid the benefits of technological disruption. So it's better to embrace it in a manner that is best suited to their personal institutions. Now, of course, I have elaborated on the pros of big data and AI. However, I would also like to talk about the risks of over-digitalization. Now, the problem with placing an entire institutional mechanism in the hands of an algorithm is that a single security breach could lead to the collapse of the entire system. So as opposed to the traditional banking systems where the risks are more scattered and therefore easier to mitigate, once you place it into an integrated technological network, everyone with a phone and an internet connection can have access to banking services, which is great. But the fact that there is pseudo-anonymity, for example, with the blockchain network, it creates a lot of problems for really determining where that credit goes. So there are a lot of problems with attestation and a lot of problems with verification of where the credit is going and what is being used for. For example, I think it was in 2011 when the Silk Road, which is an online platform, was using Bitcoin. It's basically on the deep web, and they were using Bitcoin as a form of currency to trade a lot of contraband and illegal goods like drugs and weaponry. And that ultimately led to their shutdown, and it led to a conscious understanding that Bitcoin is not it's not an all-end, it's not a straitjacket solution to the problems that we're currently facing. But again, harnessing the technological developments that come about is the primary objective that we must focus on. So this is just a brief understanding of how blockchain operates. Blockchain is essentially a distributed ledger wherein every individual has an alphanumeric identity code, and all transactions that you undertake in the ledger are recorded for eternity. So your authenticity and your credibility as a user of that ledger is authenticated by itself, and it's a self-serving and self-perpetuating system. But of course, as I mentioned, there are cons to the same. So this is a study by PwC on the most promising fintech opportunities in India, and leverage existing data and analytics is of course one of the highest on the bars, and improving customer retention. Now, why this comes into play is because a lot of banks and a lot of companies are now engaging with AI robots and AI customer service that essentially, you have Siri, you have a lot of these online, customer service and personal assistant applications that tap into your personal desires and your needs, and they give you a customized response and customized feedback. So once people are happy with the kind of experience they're receiving, they would be more responsive to come back to the same institution. So it's a way to incentivize consumer relations, and a way to incentivize repeat sales for banking and other industries. Now we have to ask ourselves the basic question about whether or not we will be able to keep up with robotic change and with all of this disruption, and whether we in fact will have a place in the workforce, say 12 to 15 years from now. With the Industrial Revolution, of course, the threat of automation that is not new and has been existing since much before, since the 1800s, is that would I, as a human being, would I, as a member of the workforce, become redundant? Would I be able to contribute any significant value to the workforce? Or would I be able to keep up with acquiring certain skills and technical capabilities that would make me valuable and would make me employable as an individual? So the primary difference between the Industrial Revolution and the current disruptive wave that is happening is that then the replacement was merely for physical capabilities, whereas now it's physical plus a cognitive replacement, where AI and robotics are able to understand human needs. For example, in Japan, the demographic is fast aging, so they don't have enough young persons to take care of their aging population. So they have created robots to, perform elder care and really anticipate the needs of the people that they're serving. So we see that there's a lot of research that's happening in the area of EQ development, that's the emotional quotient development of a robot, right? Because this is what we as humans so severely pride ourselves on, this idea of an intuition. But if you think about it, it's more of a pattern recognition than intuition. So if an AI could effectively collate and analyze information in real time, in say nanoseconds, and also have the ability to tap into human desires and emotions, what would our value as human beings of the workforce really remain? So this is one of the most pressing and, in fact, I feel intimidating questions that this wave offers. However, a lot of scholars believe that our primary role in this wave would be really leveraging and servicing AI, which would mean developing the capabilities that would help to improve the existing wave. But again, the question about whether or not this is viable would depend upon whether our governments have the infrastructure to support the monetary resources to support this kind of shift. And this is the primary question that I'm seeking to answer in this paper. So this is again about how we're moving towards a more holistic understanding of what robots do, and the fact that they're not just the same people who the same machines who have very, very technical capabilities and are very rigid in their understanding of what their performance should be, but they're moving towards a more human-like and more individualistic combination of thoughts. So the concluding remarks, I would just like to elaborate on the fact that we could obviously think of it as a kind of outsourcing to robots, the fact that we are moving in an epoch where we feel like we should be relegating ourselves to more higher end and more sophisticated means of work. But what I believe is that unless our infrastructure and capabilities really reach a point where we can sustain this very, very dynamic pace of technological disruption, the redundancy will, of course, be a factor that will determine whether or not we will be able to harness this change. But right now we're at a crossroads, because unless we reach a point where we can really be confident about leveraging the kind of AI that we're so confidently developing, it may not pan out as successfully as we think it to be. Any questions?
So first, I would say that Pranav should start with a critique and a question.
Sure. Yeah.
And then, Professor, I'd like for you to give your remarks, and then if there are any other questions remaining, then we'll open the floor to all those questions.
Hi, sir. Thank you. Take officer. Take office.
So, thank you, Varsha, for the presentation before. It was a really interesting paper to listen to, because I primarily like one point which is quite novel, which I haven't heard before, which was the emotional quotient part. Because whenever we talk about AI and about the mechanization process, the only aspect which is often referred to is how it would turn the workforce as obsolete. It would lead to unemployment and a lot of other problems. But the idea of us becoming emotionally redundant or emotionally the only distinguishing factor between humans and robots is that we have emotions, we have cognition. That is also something which would be undermined, as Varsha has rightly pointed out. So that was quite an interesting new concept that I got to know. So
Can I?
Yeah. Of
Okay.
course.
I need the clicker.
Yeah.
So this is nothing to do with the paper, but you know, general presentation technique.
Yes.
What's wrong with this slide?
Readability.
You don't put white font over a cloud, okay? You learn that once you go along. And also, it was this slide here, at the very beginning. Nobody is going to read all that. 6 points on the slide, maximum. Because you don't want me reading these things, you want me to listen to you.
Right.
Okay? So these things, whenever you do slide presentation, look at the colors and 6 bullet points on the slide. That's the maximum they do. Because PowerPoint slides shouldn't be a substitute for a presentation. They should be a complement. Okay? It doesn't mean you have to use all the pictures in the world, but have the bullet points so that people every now and then, kind of like a table of content, know where you are. Graphs are absolutely fine, but don't have like pages of text that just distract. And also, you know, it takes too much time to make them. Okay, but this is just in terms of presentation. The way you present it, absolutely fine, perfect. Don't worry about that. Just make the slides much simpler.
I will.
So now on the substance. My first question. This is why I referred to you. You're
Yes.
writing a legal paper, right?
Yeah.
You didn't at any point in time mention on your slides have the word law, unless I missed it. What is the legal aspect of your paper?
The legal aspect is the regulatory mechanisms that we would be employing. So the fact, I understand that I haven't delved into the legal aspect of it.
You made a good defense saying you don't have a research question yet, right? And that was kind of like where I thought, okay, there's something's going to be missing. But if you present a research paper, I know it's the question about how you regulate liability of AI, how do you regulate consumer protection, and so on and so forth. Also fundamental rights, data protection. At least have one part where you then demonstrate in this stage of the paper, these are the regulatory challenges. This is what I'll be looking at. Okay, because if you have an even meaner professor, they'll just say non-legal in the next paper. Okay, when you write a legal paper, say in the very beginning, where is the law? What are the legal issues? Even if you haven't developed them properly. That's what I did 3 years of my PhD. I didn't have any substance. I just said, oh, these are the problems, and you know, I'll see you in a year, and then you know, you work with them. But at least I gave them something to think about, and most importantly, made them think, oh no, he's on a good way. He knows what he's doing. But this is one of the things that I've observed with many students that write about new technologies. You are currently in a phase where you try to understand the technology, right? Where you try to put everything together that's happening in the real world, and only then can you reflect about the law. But think about it parallel, because then you're also better able to analyze on the spot and identify the interrelations between technology and the law. But what are the things you will actually be looking on from a legal perspective?
From the legal perspective, what I'll be looking at is from India, there's not really any regulatory stance because the central bank has not given its ascertainment on whether or not it would be accepting Bitcoin, but it has accepted blockchain. It has released a few press notes on the potential applicability and the mechanisms that could be employed. But there is no such regulatory clarity that exists today. If I were to make a comparative thesis with, say, the US, wherein the SEC comes in and then you talk about fintech as a commodity or as an asset or things like that, I could move on to there, but then again, I wouldn't have a very level playing field between India and the comparative version of it,
Okay.
unless I reach a point where India has regulatory
Okay.
certainty.
That shouldn't necessarily be a hindrance, even if you have a completely different system, you can still try to compare it, or at least say how any law could develop.
Right.
But that would assume that you take the American system as an ideal, as something you would want to work towards. So then maybe then take 2 other countries, compare them, but that might then be a bit too much in terms of research. If we go back to the very beginning of your site, you said you do quantitative research. In your very first slide, some of the methodology is quantitative. What do you mean by that?
So the quantitative research, essentially, I'm currently accumulating data and statistics about
Okay.
how fintech and AI is panning out. So I later, on one of the slides, I showed the possible applicability of fintech and the mechanisms that could be used in terms of different industry and sectors.
Okay.
So that is, I'm using a more observational come quantitative approach.
Okay.
How do I see the
Be careful with the wording quantitative,
Right.
because that might be slightly misleading. Okay, quantitative research usually refers to data collection and analysis. Okay, only collecting lots of information doesn't mean it's, yes, it is a quantity, but it's not quantitative analysis. Okay, quantitative analysis usually requires the use of some software where you have you just collect statistical data, but you create the data in one category and collect it yourself. That would be quantitative analysis from a methodological perspective. Okay, so with that you should be careful, but this is just a terminology issue. A more grave concern, so there are two things you could change, either your title or the scope of your paper, because your title is the disruptive role of AI for the banking and finance industry. What does blockchain has to do with AI? How are they interlinked? Because you talk a lot about blockchain, but not so much about AI. And in my opinion, a blockchain is merely a tool. No?
Right.
It is indeed a register where a community in several places as a verification tool registers transaction, registers movements of things. But it has, in my opinion, nothing to do with AI directly. AI could use it as a source it taps into, as a data pool.
Yeah.
So when I read your abstract yesterday night, I thought, and you jumped quite quickly, I think, part two to blockchain. I said, this is not AI, this is not AI, this is not AI. So gear the focus towards AI, and I think there you have many more legal problems to solve, even from an ethical perspective.
Right.
So tone that blockchain part a bit down, because that really confused me on how that, because you have this one sentence, blockchain and AI are, to me, more or less the same or strongly interlinked. I would say they are not. They're completely different things.
Right.
But of course, they can be interlinked for a specific purpose. Okay, they're not the same. They're not at the same level. Yes, they're both technologies. But then you also should, at the beginning, give us a definition what you consider is AI, because that's also disputed in the descriptive definitional part. I think there's one standard definition which more or less AI is something that emulates the human conscious process or something like that. It's kind of like a generally accepted definition, and then work with that. Okay, and then you can also easily distinguish that from blockchain, which is really a transactional recording. Okay, really nothing more. So, but in the beginning, I understand that students always jump a bit, what sounds exciting, and put everything together. Quickly move beyond that point.
Okay.
And really then filter out the things that you really want to focus on, because how many pages can you write? Maximum?
It can go on. I mean, there's no such word limit.
Really?
I mean, 5,000 words, so I'm guessing about
Okay,
30
so
to 40.
this is not much. Okay,
Yeah.
you won't be able to put everything blockchain and AI in one paper in
Right.
5,000 words. Yeah? So really try to tone it down a bit and highlight the legal element. So always describe something, but dump very quickly in the legal, because reading one of these papers, then as a lawyer, you then skim over the technical parts because nobody really likes that, and you go to the legal part quite quickly. Lionel Bentley once told us, when he reads law and economics paper, he always skips the numbers. He doesn't care about them. That's where most of the effort goes into law and economics papers. In the same way how I read technological papers, I just skip that part and go directly to the law. If I need something, I go back. So that would be wasted space. Focus on the law, not the technology. Describe it as much as possible and necessary, but then go into the law. You have something else? Yeah, no, that's more or less it. These are my remarks. But otherwise, it's interesting. You're not the only one researching on that. But make it, in a way, as far as possible, unique. And focus on something that not everybody is writing upon. So find one or two legal areas and apply them to the use of AI in banking system. And whichever area you choose is then completely up to you. Also reflected in your title, which is still a bit too broad.
Right.
And then you know exactly what's coming in the paper. much time do you still have on paper?
There's no tentative date that we have
Okay,
decided.
okay. But if you want to have more on blockchain, if you need support, look at the University of Amsterdam, the EVA.
Okay.
They have now, I think, the only big blockchain project. And they recently had a paper out in GPTech, I think, on blockchain and copyright law. But the good thing is they cite a lot of general blockchain literature. And on their website they have all their publications in reference to other blockchain.
Right.
I think it's AI. Look into what Anna Ramallo is writing from Maastricht. That might be very. She's the leading scholar in IP and AI and banking. Yeah, they do that in Luxembourg, but that's why I left probably. We wanted a long conference on new technologies in fintech and in banking, organized by the Luxembourgish banks, which was like 300 people coming and everything. Horrible. But this is something that is then really mainly done by financial lawyers. And there's a lot of stuff around, but I wouldn't know where that comes into.
Yeah.
Should I begin, Professor?
Yes, of course, and please don't call me professor. That's
Good morning, everyone. I'm Pranav Pafna. I'm in my third year of law school, and today I shall be presenting on should India be bothered about personal data classification. This is a subset of a larger paper that Professor Tripathi wrote on examining global norms on data protection for determining ISP liability in India. And it's a huge paper which has comparative analysis of various jurisdictions, but I should just be dealing with India. So, largely the paper is about the ISP liabilities and the data protection norms and the regime which exists all over the world. This is particularly important with regards to cybercrime divisions as in law enforcement, since the law enforcement generally make representations to the ISPs in order to gather information with regard to any cybercrimes. So one might ask the question that why is data protection essential? So this becomes essential for primarily 4 reasons. First is national security. Second is confidential information of businesses. Third is rising cybercrimes. And fourthly, preparedness for various eventualities. Cybercrimes have been on the rise, as many of you might be aware. Quite recently, the National Green Tribunal site was also hacked. And in 2012, I believe, Delhi High Court Bar Association's website was also hacked. So there have been multiple incidents of cybercrimes. So let me talk a bit about ISPs, if you're not aware. So ISPs are essentially electronic intermediaries and service telecommunication providers, and they gather a lot of information which is personally identifiable information, which refers to information which can be used in order to identify a particular individual. Such information becomes useful as evidence in cybercrime prosecution. So if any, and such information is, in criminal investigations, a large number of jurisdictions all over the world have placed various obligations on the ISPs to disclose information in order to help in the investigations. So if any of you are thinking of committing cybercrimes, please be aware that the ISPs can disclose your information to the police and the investigation authorities as well. So now on to data retentions. Now data retention law in India is primarily governed by the IT Reasonable Securities Practices and Procedures in Sensitive Personal Data or Information Rules 2011, coupled with the IT Act of 2000. Now subsection 2 of section 67 provides punishment of up to 3 years and fine as liability for the ISPs if they do not retain the information which the law prescribes. Section 67C has to be read in consonance with section 69, which provides the various intentions or the uses with regards to which the authorities can gather information from the ISPs. These are interest of sovereignty or integrity of India, defense of India, security of state, friendly relations with foreign states, investigation of any offences or cognizable offences. So it's largely with regards to these that the police can gather, that the investigating authorities can gather information from the ISPs. The rules also provide for when to use, retain and withdraw the SPDI. SPDI refers to sensitive personal data or information. So the data controller can use the SPDI for specified purposes only, which essentially means that the organization, that the ISPs which gather the information cannot use this in any manner that they deem fit, and therefore it's regulated. The rules also require the data controller that deals with sensitive personal information to have a privacy policy and publish such policy on its website. There are also grievance officers which are established as per the law, who are there in order to address any privacy concerns which might arise with regards to the same. A data subject can also withdraw his consent with regards to the collection of information if he deems so. However, as we are all aware, when we enter into contract with huge corporations, the bargaining power with the consumers is not really much, especially when it comes to various necessary commodities. Due to this, and furthermore, a lot of us might not be even aware of such ISPs gathering information, and therefore we provide meaningless consent in such situations. Now the question arises, can the SPDIs transfer the information to third parties? The answer to this is yes, provided that the data subjects of course consent to it. Now again, as pointed out before, such terms might be inserted into contracts, and without even going over the terms and conditions, we sign these contracts, which essentially means that the private information, that the sensitive personal information that we have, we essentially give the ISPs free rein over what they want to do with it. And hence it becomes extremely essential for us to be aware of our rights and whether we can withdraw our consent from such contracts or not. If, however, they transfer without the consent of parties, then they face an imprisonment of up to 3 years or a fine up to 5 lakh or both. Moving on, the Central Government of India on August 24, 2011 issued a clarificatory press note to the IT sensitive personal data rules. They are describing that the body corporate as defined in the rules refer to the body corporate in India. What this essentially is a step towards data localization. Before the notification, there was no data localization norms which existed in India, and even after the notification, no such laws have been built upon it. It was just a clarificatory note that was issued. However, without data localization norms, what is essentially happening is that, say, WhatsApp India gathers information about you. Now they upload the information on the cloud. Now the cloud services, the WhatsApp headquarters in the USA can tap into the cloud services and use the information. And considering again how we've all consented to their terms and conditions, there's nothing we can do about it. Hence, in the quite long ago, a lot of cases had arisen against WhatsApp India and against Facebook with regards to the information, personal information that they are divulging to the organizations, to their parent organizations. Now there are certain pressing concerns which evolve with regards to this. The first is, of course, that the classification of information in SPDI is problematic. The law only protects certain types of personal data information and which is not enough in order to ensure a great deal of privacy. Especially with the recent judgment of Puttaswamy, which has completely elaborated and expanded the privacy which existed, the privacy norms which exist. It would be quite interesting to see the impact which occurs on the data classification norms in the near future. Then secondly, lack of localization laws make things more problematic. And creating a large database of citizens' personal metadata without proper security and legal framework would mean that we are putting the personal information of the individuals at great risk. This was one of the most pressing concerns in the Aadhaar debate, which was brought up by a lot of legal counsels as well. And lastly, the current data protection laws of India provide limited protection for certain type of sensitive information only. Now, at the end of the paper, Professor Tripathi came up with certain policy suggestions which could be invoked. First, that personal data be secured by attributing a higher standard of protection to it by mandating ISPs to be vigilant about the possible misuse of data held by them. Secondly, data processing norms must be based on universal industrial practices. So while localization laws will make things more effective, it also creates a lot of problems for the businesses as well, because now they do not only have to conform to the global standards, they also have to conform to the local laws. This creates problem and increases cost for them. And lastly, a consultative framework with industrial leaders, interagency experts and externals from academia and civil society will aid in striking a balance between individual rights and market realities. With this, I end my presentation. Thank you for your
So any questions for Varsha, why don't you start with the critique?
So, what would be your opinion on the general data protection regime in the EU with regard to the fact that, given how you mentioned Facebook and even Donald Trump's run-in with Cambridge Analytica, the fact that he had been using a lot of personal data and in collaboration with Facebook about his electorate and his campaign. So, what would be your opinion on how that fits into this regime, or whether we can take inspiration from it?
So, with regards to that, I believe that the proper principles do exist for data protection of the individuals if you want to protect your privacy. Because as I've pointed out in my presentation, you have the option of withdrawing your consent, in which case the organizations cannot save your personal information. However, as you pointed out in the case of Donald Trump as well in Facebook, since a lot of us, when we signed up for Facebook, we were, I think, 12 or 13 years of age, and we did not go with the terms and conditions. And frankly, before coming to law school, I didn't even know that it was important to go with the terms and conditions of a contract. So that explains why a lot of people, when they divulge their information, and if Facebook uses it for any purposes, which is provided in the terms and conditions, it's technically legal. Even though it's not an informed consent, it is still legal what they're doing. But just because it's legal does not make it moral or ethical in the first place. And hence, the need for a robust regime has to be, a robust regime has to be set in, where the consent is not just illusionary, where the people know what they're signing up for. And hence, so legal reform in this regard might be of some help.
I have a question now. So why do you think that the companies would consent to such a regime? Because right now they can use all the consumer data they're getting, and it's quite profitable for them. Because here we're getting all these services which are like expressed or told that they are free, but we're actually paying for them by the way of our data. So why would companies consent to all these big companies like Facebook and Google who've been providing us their services for free? Why would they consent to such a law or such a regime, or why would they be okay with sharing this data, this sensitive data, with the government?
Essentially, this is the reason why they would have to share the government with the data is because, first of all, it's mandated by the law, and the reasons why it is mandated by the law is for the investigation of offences. With regards to these cases, and especially when it comes to national security, the state is generally given a free hand, and the corporations, if the corporations are not really in a zone to object in such situations, because these are not uses which the state is using for its own self-interest or in order to harm these organizations in any way. The state is essentially using it in order to monitor any, say, terrorist activity or any threat that might exist to a nation as such. And hence, these organizations would largely cooperate, and this also ensures a better image, so to say, for these organizations, because if they are helping the authorities in order to catch criminals, then it also increases their personal image in the society as well. So.
Okay, I have a final question. So now that there is this new trend developing where the consumers are getting in charge of their own data and acting as the final sellers of their data, what do you think? How would these policies, or would there be any effective policies to control such an economy which is coming up? Because here in this economy, all the consumers would be the end sellers. They are by eliminating the middlemen of these huge companies.
Okay, so I believe that at this point I would be purely speculating, because considering the Puttaswamy judgment that also came out recognizing right to privacy in the Indian constitution, which did not exist before the judgment per se, the impact on that, and how, and even in the constitutional aspect of it, how much control do you have over your fundamental rights, and can you contract away your fundamental rights, which you technically can't. So there might be an interesting aspect which might develop there, because right to privacy is not your traditional right to freedom of expression or right to dignity, because right to privacy has a lot of it's a developing area, at least in the Indian jurisprudence. Until what extent will you be allowed to contract away your personal sensitive information would be a new development which I really can't speculate at this point on.
That's a good point that you contextualize the privacy right from which you derive the right to data protection. because traditionally privacy was, you cannot just enter my house. And if you look at the jurisprudence in the United States and how they developed, for example, digital intrusion into your private data, they did that by the old concept of trespassing, which means physically walking into your front yard. And this is how they argued on or developed the right to privacy. So that's a very good point. I think you could, in your presentation at least, make a better distinction between the different uses for the right, because it wasn't at times very, very clear. And it's a fundamental difference whether you make use of certain information, private or not, for criminal prosecution purposes or for private enforcement. Okay? Because even in some instances, you can ask information, at least in Europe, ISP liability, starting with the case in Scarlett Senate and so on and so forth, to enforce private rights. And then different standards apply, certainly at a fundamental rights level. So this is something I would encourage you to highlight a little bit more, and that then might make it easier to understand why different standards might apply. And also there must be a difference, I assume, on what kind of data ISPs have to collect. No? Certainly connection data, who, when, where, what volume has been downloaded and what information has been downloaded, but I'm quite sure they will not download, they will not require you to collect other data you share on Facebook. Whether you like cat pictures or dog pictures, or whether you have affinity to certain brands, but it's really something that identifies where you have been at a certain time and location. It doesn't mean that this, I assume at least, that it requires you as an ISP to collect everything, but only a certain type of information, which doesn't mean, however, that they don't collect other information for which you will then need consent. For things like, when you ended, I was depressed when you said you were 12 years old. I was much older when we had our first Facebook. By then we just started having the internet. Special preferences, likes, your connections to friends. That might be a borderline case. When Facebook then has to tell authorities whether you have many friends in Afghanistan, North Korea, that might then flag up something. On the other side, I don't think Facebook is available in North Korea, but you get the point. Yeah. So this is something when you have a clearer distinction between what data for which purposes, but I assume it's somewhere in the descriptive part of the paper. But if you in a presentation give that as a first entry, that might really get everyone around, because at some point I was wondering what data are we talking about right now, or what purpose are we talking? Is it criminal prosecution? Is it enforcement of intellectual property rights, or is it just a fundamental privacy issue? And when do I need consent? And when is consent automatically given by way of a law? When do they not need consent, and when is it more or less automatically constructed via whatever law you apply then? But otherwise, no, very, very good. One element, or one slides were nice. One advice: whenever you make a mistake in a presentation, when you miss something, which obviously don't apologize. Just wait a second and say something like, "I should also mention," and then come back to that. Then people don't realize you made a mistake. And then you can more or less brush it over. Always have a sentence, don't even say what I forget is what could also be interesting, or what would help you understand this issue better, and then you can drag that part along, or just leave it out if it's unsubstantial. But never let anyone assume that you made a mistake or didn't follow your plan. Just don't. Especially again, if you have a mean professor, they would, you had this intermission there, and that's not really good. But on the other side, everything else was perfectly fine. Is the paper already published, or is that still kind of like a work in phase?
It's going to be published. We need to divide the paper a bit and apply
Okay.
it.
Okay, good. So I'll ask her to send it to me, and then because I was working with my PhD supervisor is one of the foremost researchers in data protection or in the European Union. Again, a reason, and that's an area I never engaged in myself. So he did data protection, I did copyright law, but I always got a bit of how the law developed. And you first had the Data Retention Directive, then you had the Schrems judgment, which is essentially what Facebook and which data can be transferred to another country. So the data exchange agreement, and then how the Data Protection Directive regulation developed, the big GDPR that causes so many problems, and based on which I had to watch millions of videos to be in compliance with everything. So if you work at an English university or any other university in Europe, they force you, for whatever purpose you're dealing with data, to watch a 30-minute video even the lawyers might know about it, and then this is data protection compliance. And they make that check and say, yes, he read what I honestly did. I started the video and used it and continued working. And that's because I knew everything already. But it's an interesting topic. Just when you present it, make a clear distinction. What are the uses? You can even make 2 papers out of it if you want to. Or data privacy for prosecution purposes and data privacy for private enforcement. That could be also a nice distinction. But if you have it in a rounded paper, perfectly fine.
Thank you. Well, with this, are there any other questions for Pranav? Okay. So I would like to thank Justin for his very valuable time and comments for both the papers. I think this was a very enriching experience for both the scholars. I would personally like to thank you for how you break down your paper for all of us to understand the intricacies and how accommodating you were with our doubts and questions. I think this was a great experience for all of us, and this Scholars Roundtable was definitely a successful event.